The test for legal insanity varies across jurisdictions. One of the oldest of these tests was established by McNaughton's case in 1843. Many jurisdictions still use the McNaughton test. Sanders v. State provides a modern example. In 1985, Keir Sanders shot his grandfather, W.D. Crawford, and beat him with a hammer while he was cooking in the kitchen. Sanders then went to the bedroom and shot his grandmother, Elma. He hid the house phone before fleeing in his grandparents' car. Sanders then abandoned the car in a crowded parking lot. When police arrived at the house, W.D. was dead, but Elma was still alive and confirmed that Sanders had shot them. She died months later in the hospital. Authorities ultimately captured Sanders in 2005. The state of Mississippi then charged him with 2 counts of murder. Sanders raised the insanity defense. He called 2 expert witnesses, Dr. John McCoy and Dr. Mark Webb. McCoy testified that he had diagnosed Sanders with schizoaffective disorder years before the murders. He believed that during the murders, Sanders suffered from defective reasoning because of his disease. McCoy also believed that at that time, Sanders knew what he was doing, but didn't know that it was wrong. Dr. Webb agreed with McCoy's opinions, but the state's expert, Dr. William Lott, disagreed. He believed that Sanders knew what he was doing and knew that it was wrong, because he behaved rationally and methodically on that day. He reached this conclusion because Sanders hid the phone, left the scene, and dumped the car in a crowded parking lot. The jury weighed all the evidence and ultimately found Sanders not guilty of W.D.'s murder by reason of insanity, but found him guilty of Elma's murder. The Mississippi Court of Appeals affirmed. Sanders appealed to the Mississippi Supreme Court.